Hey guys, some updates in the Marilyn Manson federal cases. First, for Ashley Smithline, the court has dismissed her case. It did it on its own accord and actually dismissed Manson's request to have the case dismissed as moot because the court did it itself, saying that it had previously warned her, and the court therefore dismisses this action without prejudice for failure to prosecute the action. Without prejudice means that it can be filed again. With prejudice means it can't be filed again. Neither of those are necessarily or normally not an adjudication on any merits of the case, but have to do with technical things like pleadings and such. So in theory, she could file the lawsuit again. Second thing that has happened is in the Bianco case, where she has filed her third amended complaint. And this is largely due to the fact that Manson had filed a motion to dismiss her claims for the Deftones causes of action. One of his reasons was that these weren't connected enough to the primary causes of action to warrant being in federal court, that if they exist at all, they should be in state court. The federal court said, no, we think it's all tied together enough, so we'll take jurisdiction over these. Taking jurisdiction, the court then looked at the merits of the claims in terms of how well they were pled. Did they meet the legal standards to be causes of action that can move forward? And in one case, the court said no and dismissed Bianco's claim for interference with future economic advantage with the Deftones, saying that she had failed to plead a critical element of the claim. Manson had said that she had not pled a wrongful act within the definition of the law to support that claim, whereas Bianco said, look, I pled that he used his power and influence in the entertainment industry, and that she is not at this time aware of exactly what he said, but she would establish that through discovery. And of course said, no, we're not going to let you do that. You have to say what he did that was wrongful, and that the wrongful act has to be prescribed by some constitutional, statutory, regulatory, common law, or other determinable legal standard. So in other words, you can't just be interfering with something or making somebody upset, because there are lots of ways to do that. You have to be against the law in some kind of fashion, or some kind of legal standard in some fashion that would make your conduct wrongful. The court concluded that plaintiff Bianco has not sufficiently pleaded defendant's conduct was independently wrongful for reasons other than it interfered with her prospective economic advantage. But the court threw that claim out and gave her the opportunity to leave to amend her complaint, which she did, and flesh that out some. Now, remember, she had said in her argument to the court, I don't really know at this point. I'll have to get it through discovery. And credit to her attorney, he didn't create something in this new complaint, which he's not supposed to, and he didn't do. I think he stuck within the parameters of what he knew. And this is what they say. Defendant Warner committed an independently wrongful act when he threatened the Deftones with actions that would disrupt the band's world tour. And this was in the context of a telephone call to the band's lead singer in a confrontation with this person, Bianco alleges. So a telephone call is not a wrongful act. And I guess my view would be, is disrupting a band's world tour necessarily wrongful? I mean, there are lots of ways to be disruptive. You could say bad things about it. You could call in a bomb threat. That would be illegal, right? You could encourage people to say, hey, these people are lame. Don't go listen to them. Is that illegal? How's that a wrongful act? So the amended complaint says that he threatened the Deftones with actions that would disrupt. And I guess my problem with that is, what are the actions? Isn't the telephone call's not what's wrong? It's the proposed actions, he said, which would make that telephone call wrong, right? If the proposed actions were, if you go on with this, I will detonate a nuclear bomb over your band stage, then okay, that's going to be enough to support this claim. If he said, if you move on with this, I will not send you any more Christmas cards, or I won't open for you, or I won't be the main act for you, or something like that, I mean, that's not wrong. So you're left wondering with this, what exactly did Manson say that is wrongful, other than that it could cost money to the Deftones in the future, which is not by itself necessarily wrongful. So to me, this doesn't clear the bar either, in my opinion, that this would be subject to another motion to dismiss later on that would be granted if the court's logic stays the same. That's how I see it. I don't see this as being successful, but it's the old college try. Having said that, on the 13th, the court is supposed to hear Manson's motion to stay the case under the trafficking claim, which under federal law has another provision that says that a case like that, and a civil case like that, can be stayed and should be stayed if there's a criminal matter occurring involving the same factual allegations. There is that here, and the statute says it includes investigation as well as prosecution. Bianco is trying to split the middle, saying that, well, the investigation's concluded and the prosecution decision is not yet made. So it's in this Schrodinger kind of situation where it's neither until you open the box, and therefore it can't be stayed because we don't know if it's going to be investigated more or whether there'll be a prosecution or not. But to me, no, that doesn't really work like that. That the investigation is something that goes on with law enforcement and is in coordination with the district attorney's office as they review that. There could be more material shared, other questions asked. So I think it's still in the process of investigation. So in my opinion, Manson should win that motion to stay. If the case gets stayed, then it would stay that way until there's some kind of resolution to this criminal complaint that Bianco apparently has made against Manson, allegations of criminal conduct to the sheriff's department. So if it stayed, of course, there'll be no further discovery in the thing for a while, no further arguments or procedures or whatever. And that leaves up in the air. Ashley Smithline has disappeared for purposes of her lawsuit. She's gone. She was, in theory at least, served with a subpoena for deposition in Bianco's case that she has never complied with. And will she do that if the case moves on, or will she rather be held in contempt? I don't think there's any way to predict what she's going to do there, or whether they'll be able to actually make her show up for a deposition. I mean, to my mind, she should just do it and get it over with. But she sees it differently. It's her life and it's her case. So we've got this hearing coming up on the 13th, and that will decide the future of the Bianco case. But for Manson, at least, that's one case down. Smithline is out. If the Bianco case gets stayed, and likely the anti-SLAPP stuff goes into appeal in the Wood Gore case where he's the plaintiff, it pretty much just leaves him at this point dealing with the Jane Doe situation. But we'll know more about that soon. Thanks, bye.